Right, good afternoon, everyone. Time is 2 o'clock and we will resume. I hope everybody had a good lunch. Now, just a couple of housekeeping matters before we continue, if I may. Any update on any documents that I was flagging up earlier?
I've seen a hard copy of the planning obligation. More copies are being made.
Super.
So you should have that very soon.
Lovely. And a final copy of the conditions, I still haven't received it electronically, and I don't have a paper copy. I have my paper copy, but I think that was an earlier version. So that would be helpful as well, please.
Yes, that's fine. I can give you a very quick update. There's just a very minor point to check. It's with us.
Okay.
It shouldn't take very long to do. We'll get that through to you just as soon as we can.
That's great. Thank you. So then there were couple of things. Technical guidance referred to in Mrs. Eads' examination. 0201. I'm afraid I didn't catch the full name of it, but she said that she would supply it. It was referred to in her proof.
Yeah, it's referred to in the LVA.
Yes, sorry, the LVA, not her proof.
She sent it to us.
I'll leave that with you. If that can be chased, that would be helpful. And also, I think she was going to provide some clarification in regards to the visuals in relation to the questions that Mr. Green asked her.
Yes, and I know the answer to this. The answer is that the document or the visuals that CD 1.40, I'm sorry, the question that was being asked was, could we just double check that the visuals at 1.40 picked up the changes to the scheme reflected in the 2024 LVA? And I think the answer is yes, they do. But I have asked for SE just to prepare a very short one paragraph to confirm that, rather than you just taking it from me.
Okay, thank you. Right, so then a couple of things that I need to flag up in terms of my own housekeeping. Obviously, we'll be carrying out the site visit. Oh, one other thing was the representations from the interested parties, that we were having copies made so that they could be circulated. Because then I can update the inquiry document list with them and circulate that. Mr. Litton, did you want to check them first, or are you? Yeah, so if you could lead them, Mr. Litton, that would be very helpful. Thank you. And then they can be checked. Thank you. And then in terms of site visit arrangements tomorrow, so we're still on course to do conditions in section 106 tomorrow, and then probably after lunch to carry out the site visit. My intention is there are some requests to view, I understand. So once we know where they're from, I'll do those first, and I will obviously need somebody from the appellant side and somebody from the council side to keep me company. Now, again, it's not for any interested parties that are here or listening online. It is not an opportunity to discuss anything that we've discussed here. So please don't try, because it means that I have to be really forthright, and I don't like that. So I'll start with those, and then I will carry out the site visit as in the itinerary that was agreed previously. Is everybody content with that? All right. Thought you were putting your line to say something.
I said yes, but I hadn't turned the microphone on by that stage.
Thought you had a particular view about the site.
No. There'll be either Mr. Packer or Ms. Barnes from Turley's who will accompany you on that.
That's fine. We can arrange that tomorrow. That's absolutely fine. Now, could the council? I'm conscious that one of the interested parties has to leave. So could the council take the list, Mr. Free? Are you able to give the list of people that want to view? Okay. Right. Mm-hmm.
One between Minor Road and the head of close.
Yep.
And then one on the junction, two on the junction of Percy Gateway and Close, and one at the entrance to Gateway.
Okay,
I think there's a fair kind of mixture there for you to choose from.
that's fine,
So
thank
I'll leave
you.
that to you.
Well, could you give it to the council and then I can make arrangements?
They're all available in the morning and after.
Yes, it wouldn't be until after lunch, I imagine. I will need food for a site visit. Interested parties are able to come on site with me and carry out the site visit. Obviously, a lot of it will be done via the footpaths anyway. So I'm happy for you to do that and we can arrange that tomorrow. Obviously, we don't need masses of interested parties to come along. But so if there are lots of people that would like to attend, it would be helpful if a representative is allocated to come with us as well. It's crowd control as much as anything else. I walk at certain speeds and the idea of being left alone with any particular party fills me with fear. So it's about making sure that we can all keep together. But if the council is made aware of anyone that would like to attend the site visit, and I'll deal with this again tomorrow, I'm just flagging it up, then that would be helpful. Super, that's all the housekeeping that I had. Mr. Green, was there anything that you need to, Mr. Listen, anything? No. Super, well, in that case, we will resume and we will deal with re-examination, Mr. Green. Thank you.
Thank you, Madam. Just a few matters in re-examination. The first, you were taken to document CD 4.4, which was Surrey County Council's response to the planning application. That formed an update to the officer's report. You were taken to that document, Mr. Sampson, and various parts of it were pointed out to you. It concerned access arrangements and so on, and the comments of the County Council on those arrangements. Where in that document does the County Council consider the effect of increased traffic on the amenity of residents of Keepsake Close?
It wasn't considered in the document.
Next issue, areas of strategic visual importance. You were taken to local plan part 1, CD 5.1, and in particular paragraph 13.44. And a sentence was read out to you, but not the following one. The sentence that was read out to you and formed the basis of cross-examination was: the areas are designated because they are considered to play an important role in preventing the coalescence of settlements, or because they are areas of open land that stretch into the urban area. The next sentence wasn't read out. They are considered to be strategic because of the role they play in maintaining the urban character of Farnham, Godalming, Hazelmere, and Cranley. That's the context. Would you take up local plan part 2, please? CD 5.3.
Yeah.
And go to its internal page 85. I'm working from a hard copy, so I can't say
No
what
problem.
the digital page number is.
That's fine. Nearly there. T5. Yes. Yeah.
Page 85, paragraph 4.20, under the heading Areas of Strategic Visual Importance, says areas of strategic visual importance is a local designation that was developed as part of the local plan brief of 1981 and the local plan 1984. The importance of the designation is to protect areas of land not protected by national landscape designations, but that still need protection because of the role they play in establishing the character of a locality and preventing coalescence between developed areas. It was put to you that ASVIs performed only 2 functions. They prevented coalescence, and they were areas of open land that stretched into the urban area. given what we've just read, is that correct?
I don't believe so. I think it wasn't as binary as that.
Paragraph 4.22 says the designation was reviewed as part of the examination undertaken for local plan part 1, but detailed boundary changes were not considered. Local plan part 1 retains the existing ASVI areas under policy RE3. And then 4.24 local plan part 2 has reviewed the boundaries in line with the local plan part 1. Given that the review concluded that the site at the Holy Cross Hospital makes a limited contribution to ASVI purpose, local plan part 1 retained the site but set out that local plan part 2 will determine the environmental value of the ASVI and its boundaries. Given what's said in those paragraphs, how many reviews have there been of the ASVI designation since local plan part 1 was adopted?
It was reviewed under the local plan part 2.
Was there a review at the
Or is
time local plan part 1 was considered?
Yes, yeah. I mean, it's saying that both of those stages, isn't it? Yeah.
Yes. And if you go over the page, 4.26, we can see it says this policy RE3 of the Waverley Borough Local Plan Part 1 strategic policies and sites will apply to the areas designated as areas of strategic visual importance on the following maps. And we can see map 26 Farnham ASVIs.
Yes.
And we can see the area, but it's not exactly the same area as the area ASVI shown on the proposals map you were taken to earlier by Mr. Little.
That's correct, yeah.
And which of these is the more up-to-date map?
Well, obviously the local plan part 2 is the more up-to-date document.
Again, what significance, if any, should the inspector take from the fact that the ASVI has been reviewed not once but twice, and that it's shown in the most recent iteration of the local plan in map 26?
I think it's of note that it has been actively reviewed at various stages of policy making. And obviously within the more recent document, it's shown as retained for the area where the site is, which is of note.
Thank you. Now, you were taken, and I'm going to move on, you were taken to policy SP1, and it was put to you that this was a strategic policy or a spatial strategy policy, and no breach with it had been identified. If you can take LPP1, CD 5.1 up, and go to policy SP1 on page 34, certainly of the hard copy.
Policy SP1.
SP1.
Yeah.
Does this policy, headed presumption in favour of sustainable development, do anything more than simply regurgitate what was in the MPPF 2012 version, or when it refers to the presumption in favour of sustainable development?
It looks, as far as I can see, identical, or very similar, if not identical. It's generally saying the positive presumption is the starting point unless adverse impacts significantly and demonstrably outweigh the benefits, or if there's specific policies within the framework that indicate development should be refused.
So what significance, if any, is there in the fact that SP1 wasn't referred to in the reasons for refusal?
it doesn't add anything over and above what is already in the national framework. It doesn't. It's not a prohibitive, or it's a general policy. Really, it doesn't really add a lot of value, I don't believe.
Does it say anything about where development should go?
No, no.
You were then taken to policy SP2, which undoubtedly is headed spatial strategy. And it indicates that to maintain Waverley's character, etc., the spatial strategy is 2, and then there are a number of provisions. The second is to focus development at the 4 main settlements. And then there's a footnote 3. What does that say?
Yes, footnote 3 is the one that I mentioned, which is for the purposes of this policy. The built-up area of Farnham includes Badshot, Lee, and the built-up area of Hazelmere. It includes Beacon Hill and Hindhead.
And what is the significance of the reference to the built-up area there?
Well, it's clearly serving the purpose of identifying and clarifying the extent of built-up boundary, and therefore it follows the implications that follow from that in terms of how development proposals are considered.
And in terms of delivery, how is the policy to be delivered?
In terms of the housing provisions, then the neighbourhood plan was the vehicle by which housing was allocated and provided in and around Farnham.
Yes, just on that point, if you can take up the local plan part 2 again, CD 5.3, page 44.
Yes, which page, sir?
Well, I've got a hard copy, page 44. I'm looking for paragraphs 3.4 and 3.5.
Okay. 3 point. Yes, yeah. Yes, I'm there.
Settlement boundaries identify the area in which development is likely to be considered acceptable. These boundaries will reflect the extent of the main built-up area, planning permissions and site allocations. As part of local plan part 2, the existing rural settlement boundaries were reviewed and updated, and boundaries for 2 of the main settlements have been established. It says in brackets, the Farnham neighbourhood plan and Hazelmere neighbourhood plan specify the settlement boundaries for those settlements. In light of that, where would one look in order to identify acceptable and unacceptable locations for development?
In the Farnham neighbourhood plan.
Mr. Sampson, thank you very much indeed.
Thank you. Thank you.
Sorry, Mr. Sampson, just bear with me for one moment, just whilst I check. It's just a point of clarification in terms of your proof where you talk, so paragraph 2.30.
Sure.
And you're addressing the council's second reason for refusal. And you say, you talk about the change in traffic movement and associated effects. Then you say some detrimental effect on the quality of life of the existing residents owing to disturbance, for example, from traffic noise, car headlights and so on, coupled with the overall erosion of the environment owing to the extended highway infrastructure. Could you just clarify for me what you meant by that?
Sure. So the erosion of the environment, what I mean by that is the effect on the character and appearance of Keepsake Close and to some extent Cascade Way from the widening of the road and the reduction in landscaping. And all that goes with that in terms of increased proximity of the carriageway to properties, and the overall changing of the balance that I mentioned in earlier, ma'am, in terms of moving away from a deliberately designed landscape-led approach within the development of Abbey View towards one that's balanced more towards highway infrastructure.
Thank you. No, I don't have any further questions. Thank you very much, Mr. Sampson. So that concludes the council's evidence in respect of topics. So we will now move on and hear the evidence of the appellant's counsel witness, Mr. Simon Packer. If you'd like to come and make yourself comfortable, Mr. Packer. And then when Mr. Litton's ready, I'm sure he'll commence his evidence in chief.
Right, Mr. Packer, I'm going to introduce you by reference to your proof of evidence, which is at CD 9.1. CD 9.1 if you're working remotely. And in section 1 on page 1, you tell us your name is Simon Packer. You're a director at Turley and your qualifications set out at 1.3 and continuing Bachelor of Arts with honours in Town and Country Planning, Diploma in Town and Country Planning, both from Oxford Polytechnic, now Oxford Brookes, member of the Royal Town Planning Institute, 25 years post-qualification experience. And before you joined Turley's in 2000, you have worked for a number of different local authorities. So with that introduction, I'm not going to ask you to read anything. Thank you, Mr. Packer. I want to just ask you very briefly to explain how we got to the appeal scheme that is currently before the inspector, which is up to 83 dwellings from a rather larger initially proposed development.
Thank you. Yes, I will avoid repeating what Ms. Eade has already said, but I think it is important just to mention again that the starting point for determining the suitable parameter plan development area was very much based on a thorough assessment of landscape and heritage constraints. And there were various iterations of that exercise that included a reduction in the extent of the development area that was shown to reduce it further down towards the lower parts of the site. That, as I say, was a consequence of further testing, and that reduced the development area and subsequent capacity of the site down from 120 to 83, which is what you see before you as part of this appeal.
And that was the basis upon which the application was submitted. Having submitted the application, was there a process with the planning authority in terms of either refinement or addressing consultee comments, etc.?
Yes, there was. So there was further testing of specific views. Again, as you've heard already from Ms. Eade's proof, that led to some adjustment and further evidence being submitted in terms of the orientation and layout that could be provided, bearing in mind this is an outline application within the parameters plan, to ensure that views of the tower were maintained from specific footpaths. And there was also an area identified for single-storey properties towards the northern end of the development area as well.
And in terms of the context in which the officer made his recommendation to grant planning permission, is there a difference between that period, I think it was August 2024, and particularly in terms of housing numbers, and the position now?
Yes, so at the time that the committee report was written, which was back in July, the housing land supply position was 3.89 years, so short of 5 years. But of course, now with the revised MPPF and the revised standard method, we have a reduction down to 1.28 years supply. That is as set out in the statement of common ground. So I say that in the context of the officers referring to the various planning balance exercises that needed to be done at the time, and that given the more extensive shortfall that exists now, I would suggest that that balancing exercise would be slightly different.
Different in which way?
Different in that the extent of the shortfall is more significant, and therefore the weight that I would apply to the delivery of housing should be given substantial weight.
Okay, and on this topic, two issues. First of all, what is the latest information, as far as you're aware, in terms of this borough making progress with its local plan review, which I think, according to its LDF, suggests Reg 18 consultation in May this year?
I would suggest, given the starting point is that they need to deliver substantially a greater number of houses, that will require an extensive amount of work to ensure that the right sites are chosen on the basis of all the relevant constraints and opportunities, that they are assessed properly through a thorough sustainability appraisal. And I personally consider that that timescale is very tight.
So, I mean, given that the standard methodology now mandates a figure of over 1,400 from something like under the existing plan 500 or so.
Yes, that's the difference. So previously the requirement was 590 dwellings per annum, and now that's uplifted to 1,481. You have an authority that is heavily constrained by Greenbelt and by National Landscape Designation, Surrey Hills. So that presents challenges in itself that, again, I would repeat, would require a significant amount of work on the evidence base to justify the plan that comes forward.
And is there any evidence as to, or are you aware of what progress, if any, has been made in relation to that evidence base to find sites for 1,400 dwellings per annum?
I don't know for certain, but I can imagine that very little, on the basis that although a draft MPPF and draft standard method were published back in July, my experience of many local authorities is that they have decided not to commence work on the back of a draft MPPF on the basis that it may or may not be, obviously, a final version. So once the final version was published, which was December, you're obviously left with a very limited amount of time from December to now to actually commence any work in earnest.
And are you aware of what the resources are available to Waverley in terms of its planning department?
I think, like most authorities, the resources could be much more significant than they are. I do have some sympathy with them in that respect. I know the government has pledged additional funding, but we're yet to see that work its way through.
And so if you were having to put a timeline on a new plan being adopted, what would you realistically say that would be?
Well, I would suggest a Reg 18 probably at the earliest, much later this year. So on that basis, I would suggest, and it is a little bit of finger in the air, but I would suggest probably later 2027, early 2028 at the earliest.
And in the meantime, is there any published document by the council as to how it's going to address its shortfall in housing land supply?
No.
All right. Then the so can we just move on, please? In terms of issue number 1 identified by the inspector, i.e. the principle of development on this site, we've heard from Mr. Sampson that although there is no case being made by the council that there's a breach of either SP1 or SP2, he says that it's not in principle acceptable development in this location. What's your position in terms of that issue, i.e. the acceptability in principle of housing development on this site?
So I think there are policies and references within Local Plan Part 1 that do suggest this site should be compatible with and comply with the general spatial strategy. And I refer specifically to policy SP21 of Local Plan Part 1, which is CD reference 5.1, I believe. That confirms criteria 1, that it should avoid development of the highest amenity and landscape value, and 2, focus development on the 4 main settlements, including Farnham. I'd also take you to the spatial vision and paragraph 3.2, bullet point 2. And that confirms that development should be directed
Sorry to interrupt. What document are we in?
Sorry, this is local plan part 1, spatial vision, paragraph 3.2, bullet point 2.
Thank you.
Directing most new development to the main settlements, and that includes Farnham. And then there's a latter reference to this will include some new development on greenfield land on the edge of these settlements. So yes, I believe there is some compliance with those spatial vision and those spatial policies.
And is that position affected by FNP 10? Mr. Sampson's position being, well, whatever the SB1, SB2 says, the Farnham neighbourhood plan defines a settlement boundary. It's outside of that settlement boundary of Farnham, therefore not in principle acceptable for development, suitable for development.
Yes, so sorry, apologies. Yeah, so that is on the premise, of course, that paragraph 14 applies. Paragraph 11 we know does apply because the council cannot demonstrate a 5-year supply. There is a significant shortfall. So if you apply paragraph 11 and you do not apply paragraph 14, then of course you have to consider the tilted balance in favour of presumption in favour of sustainable development, and that would include sites such as this that are located on the edge of main settlements and can be considered highly sustainable, in my view.
Whilst we're in LPP1, your views about the ASVI, which are then reflected in the policy RE3. You may recall I asked Mr. Sampson some questions about paragraph 13.44 and the purposes for which areas are designated as ASVI. What do you understand to be the purposes for which they are designated?
So there are two purposes, and I believe it is most relevant to refer to the policy that is in Local Plan Part 1. That is the policy, and that is policy RE3. That is the primary policy, and that does refer specifically to two specific purposes, and that's set out in paragraph 13.44 of Local Plan Part 1. One, it is intended to prevent the coalescence of settlements and also to include land, include open land that stretches into the urban area.
All right, and Mr. Sampson identified that in LPP2, the boundary of the ASVI had changed. I think it was page 85. Just get it up. Of LPP2, which is CD 5.3. 86, areas of strategic visual importance, PDF, page 86, also happily 86 internally. And we can see then over the page that the boundary was amended slightly to remove the two spurs or prongs that were identified in certainly one of the prongs identified on the original LPP1 proposals map. Can I just ask you please to jump back to paragraph 4.21, where these aren't the purposes, but these are the issues that the designation seeks to address, 1 through to 6. In terms of those issues, what do you think that the revised designation as ASVI is intending to address?
So I think it's fundamentally changing the original intention of the policy. It's expanding the criteria by which you could consider the site plays a role. I think looking through a list of those designations, that could apply to a number of areas around the settlement. In terms of the individual elements of that criteria, most of the land that's identified within ASVI would potentially be vulnerable to development pressures. I think in terms of some of the other criteria, I don't believe it plays a role in preventing, in securing coalescence. I don't believe it's a small area of land on the urban fringe. So yeah, I think there are a number of different criteria there. I don't consider the site plays a significant role in those, with the exception of, as with most sites within the ASVI, you could regard it as being vulnerable to development pressure.
Okay, thank you. I'm going to turn now, please, to sort of two allied topics. One is impact of the access proposals on the character and appearance of Keepsake Close, northern end of Keepsake Close in particular, but perhaps the Abbey View developed more widely as well, together with the impact on amenity, which, as I understand, is largely restricted to the northern end of Keepsake Close. So do you want to just start with what your position is, having heard Mr. Sampson's evidence, as to what you think the impact on the character and appearance of Abbey View, so Keepsake Close, Cascade Way, would be as a consequence of the proposed access arrangements?
Yes, so I guess the starting point would be that I consider the most fundamental element of character and appearance of Keepsake Close and Cascade Way would be the tree planting. And as we have heard and has been agreed in the Statement of Common Ground, we have a tree replacement strategy that is based on a worst case scenario, I might add, to replace those trees with trees of a similar size. So on that basis, obviously that can be secured by condition as drafted. on that basis, I think the primary issue, or the primary concern, I should say, in terms of character and appearance has been addressed. It wasn't something that was considered as an option in the determination of the application at committee. However, helpfully, we have been able to discuss post-decision that a replacement strategy can be provided and indeed has been secured. In terms of the other aspects that might be argued to affect character, I think you are left with the loss of the verge, and there are detailed plans in the Statement of Common Ground, Madam, that you can look at to determine whether or not you feel that is significant. My view is that the loss of 700 millimetres of verge along the majority of the west side of Keepsake Close and northwest side of Cascade Way is not significant in the context of the remaining verge. I think where I would agree that there is very limited and specific impact is on the loss of the verge on the northern part of Keepsake Close on the eastern side, and that is particularly in and around number 18 Keepsake Close. And I say that because simply that there is the ability for people to walk along the footpath that is created as a consequence of the loss of that verge, and they would be closer in proximity to the front elevation of that property. So there is a very limited and specific impact on the privacy to those front windows.
You're straying now into the amenity consideration. I'm still on the character and
Yes,
appearance. So the loss
apologies.
of verge, as I understand it, not generally of significance, but you accept that there is a greater loss of verge around number 18.
Yes, apologies.
In terms of the proximity of footpaths to front elevations or elevation, property elevations, is that proposed relationship by number 18 with the access, is that an unusual arrangement in Abbey View?
No, it isn't. There's a mixed character in Abbey View, in my opinion. There are variations. Most of the properties are relatively close to the frontage, and most have footways, footpaths, hard surfacing that are very close to front elevations. So there's a variation. There are examples of similar character areas within Abbey View where you have that proximity of footpaths to front elevations. So I do not consider that in itself to be a justifiable reason for refusal or an issue of any concern.
Okay, that's the character and appearance of the area. What about then the impact on amenity? You touched on the impact on the amenity of number 18 again, to some extent some loss of privacy. What about the concerns that Mr. Sampson has about, for example, the headlights, about increases in traffic, noticeable changes in the increase in traffic, and indeed associated impacts such as noise? Yes,
this is covered in part in the rebuttal proof, Ma'am, if that helps you, but I'll just run through these quickly. So in terms of the specific issue that was raised by Mr. Sampson in his proof related to the effect of headlights extending southbound from the new development along the access road and affecting the amenity of number 18 Keepsake Close. I think there are a number of things to bear in mind in the consideration of that particular alleged effect. One is that obviously cars will only be using their headlights at certain times of I was going to say the day, but the night and dusk and dawn. It would only relate to traffic that is flowing southbound along that access road, where the lights are directed towards the windows. Of course, when you are dealing with headlights in urban areas, they should be dipped. And my understanding is that the lights on most cars are dipped in a way so that they the near side curbside light is directed inwards. So there is also actually a degree of planting in front of number 18 Keepsake Close as well. You will see this, of course, on your site visit. So those are considerable mitigating factors that I would suggest would result in no material effect on the amenity of that property.
And again, bearing in mind this is an urban environment, is the intrusion of headlights or lights from cars through windows of residential properties in urban environments in any way unusual?
No, often design criteria are such that you would want to provide properties that address street frontages, particularly on the corner. So they will be facing the road, and they'll often be positioned opposite junctions to provide a landmark building. So it is not an unusual situation within urban areas, and indeed is not an unusual situation within Abbey View itself in terms of other properties.
Okay. Now, noise, we were asked to check, I think, weren't we, in the noise impact assessment that is attached to your proof of evidence, the figures, the traffic figures that were used for the purposes of the noise assessment, because there appeared to be some discrepancy between the TA figures in the AM/PM peak and the figures that were used. I think it's in the table that follows paragraph 6.3 of that momentum note. We want to perhaps just pull it up. It's attached to your your proof of evidence. So it's appendix 7 to your proof of evidence. And I think what we were being asked to check were the figures at the tables at 6.3.
Yes, that's correct.
Now, I know that task is in hand, and I believe that Quantum, I think it is, as a matter of fact, correct that the figures that come out of the transport statement are a little bit higher than the ones they used. Is that right?
That's my understanding. Yes,
Okay.
there is a very marginal increase in traffic
All
generation.
right. And so are Quantum rerunning the figures to see what that impact would be? But is there any indication as to what they think the significance of the increased figures might be?
Yes, there is. It does not change their view that in terms of the noise generation as a consequence of the additional traffic generation, there is a small increase relative to obviously the assessment of the increased traffic generation, but it is not an increase that would conflict with any technical assessment and advice set out within World Health Organization standards that would normally be used by acoustic consultants.
Okay, but they are looking at that now, aren't they? And they will report as soon as they come back with what they say.
Yes, yes. So we should, I would believe, very shortly have an updated assessment for you that we can submit formally to the inquiry.
Okay, good. All right, then that is I think, amenity and character and appearance. The last thing I wanted, not quite the last thing, paragraph 14 NPPF, you will have heard the debate, the discussion I had with Mr. Sampson. Do you want to just give the inspector the benefit of your views as to how you understand paragraph 14 to apply, and whether it is relevant to consider the weight that you give to paragraph 14?
Yes, so in my opinion, if you take a step back from the detail of the paragraph, I think there is a judgment to be made in the first instance. And perhaps if I can use the analogy of a 5-year supply and determining applications on the basis of 5-year supply. 5-year supply, we know, can change at short notice. We also know that favourable decisions can be made at appeal and at a local level where there is more than 5-year supply, marginally more. So, for example, 5.02 years, it's perfectly reasonable for a decision maker to conclude that given the very marginal increase above 5 years, even though technically the tilted balance would not be engaged, it is still relevant to consider whether or not the delivery of housing would be significant enough to outweigh other considerations. So applying that to paragraph 14.
Well, just before you do, what about the other way? What about where the housing land supply, even though government policy says there is a requirement for local authorities to be able to demonstrate a 5-year housing land supply, what happens if it's 4.95 years? What weight is then given? Does the weight change that is given to the policy requiring a 5-year supply in circumstances where it's only just under?
Yeah, it's similar in the sense that it is for the decision maker to decide how significant that shortfall is and whether or not it is necessary to apply the tilted balance.
And are there examples of where, for example, that shortfall is very small, so the tilted balance is engaged, but because it's so small, a decision is taken to refuse the appeal?
Yes, on the basis that, say, other considerations come into play, and that might include the short-term delivery of housing sites that are known to be active or about to be implemented.
All right. Now that's your analogy. What then? How does that help in terms of paragraph 14?
So with paragraph 14, if you take a step back and you were to, in this instance, you were to be aware of the fact that a neighbourhood plan was expiring in the short term, I think it is reasonable, using the same analogy with 5-year supply, to suggest that you can put some weight on that in determining the relevance of paragraph 14 or not.
Okay, good. Then I think the inquiry document 11, which is the agreed and updated allocated site delivery table relating to the sites in Farnham. I mean, there is a small difference between you of, I think, 18. Is that actually significant, that difference between you?
It isn't, we could argue I'm being slightly pedantic here. It is simply that it's 18 dwellings, frankly. But I was keen to make the point that the reduction that I've applied was based on local evidence gathered as part of the neighbourhood plan, which I think is of more relevance than a wider data set that's applied across the whole borough as part of the housing delivery test. But it's to answer your question, it's a very small difference.
Okay. The bigger question is, let's just assume for the sake of the argument, the council is right and it's 218. How does that agreed figure of 218, what does that tell you about the delivery of housing on sites allocated for development in Farnham? It's about the delivery. How are those sites delivering, in other words?
So, of course, we are talking about minimums. That is as set out in the Farnham neighbourhood plan. So there's an expectation of minimum delivery. So if we assume the LPA suggested figures in the neighbourhood plan allocations table we've just discussed is correct, 218. That compares with a minimum requirement, residual requirement of 697 that was set out in the relevant policy of the Farnham neighbourhood plan that dealt with housing provision. I think that's FNP 14. So there is still a shortfall, even if you took into account the recent reserve matters approval for Coxbridge Farm at 320 dwellings. If you put those two together, obviously that comes to 538, I believe, by my maths. So you are still short of the minimum requirement in terms of sites that have delivered and have been built and sites that have planning permission. So the remaining sites either, and the majority, as you can see from the table, do not have planning applications submitted even. But even if you, and there are others that have planning applications pending, the point being that in terms of certainty, there is still a shortfall relative to the Farnham neighbourhood plan minimum requirement. And we are talking about a plan that is nearly 5 years old, as we know.
All right. And can I just ask this? I mean, one of those sites, Coxbridge Farm, in the table, allocated for 350 dwellings. Is that the largest of the allocated sites in the Farnham neighbourhood plan?
Yes, it is.
Is that also a site which is a strategic site allocated by the LPP 1 under policy SP2?
It is, yes.
And can you just jump back to policy SP2, please, Mr. Packer? You've got it. So that's CD.
Yeah, not far away.
Not far away, 5.1.
Yep.
Page 39. It's number 7 in that policy. So policy being to allocate other strategic sites, and then which one is Coxbridge Farm? SS?
I am not sure without checking. Bear with me. SS1.
SS1. And then it goes on, additional sites will be identified in local plans and neighbourhood plans. Given that it's already allocated as a strategic site as SS1, the allocation in the neighbourhood plan of it as an allocated site, is that an additional site to SS1?
It's not, no.
All right, then wait to be given to benefits, disbenefits? So inquiry document 7. And again, you'll recall the debate I had with Mr. Sampson over the disbenefit, the landscape harm, where he gave significant weight to the disbenefit, but that was on the basis that there was high levels of harm as assessed by Mr. Petro to the the landscape of the appeal site, but also the two other receptors, LCA4 and LF6. We know that that has changed and that he now agrees with the appellant in terms of what their assessment is for those two character areas. Does that say, given that concession that has been made, first of all, is that concession a significant concession?
I would suggest it was, yes.
And on that basis, what's your view as to the weight that he's given to the landscape harm? Does it reflect that concession?
I don't think it does. I think it brings it into the category of moderate, given that those concessions included a lot of agreement with the evidence presented by Ms. Eade. I think that would suggest it's reasonable to conclude that the level of harm should be consistent with our assessment, Ms. Eade's assessment, which is moderate.
Okay, good. And then the last thing is, I think right at the beginning of proceedings yesterday, we referred to the Environment Agency updating its flood maps. And of course, in your proof of evidence, you included a technical note from Landmore Consulting. It's your Appendix 3. And we said that that had been updated. I don't think it was ever distributed. So can we just deal with that now? Let me. Have you got a copy of it? Oh,
Sorry, I don't. Thank you.
I mean, it's rather speaks for itself, but do you want to just perhaps just summarize what the position is?
So yes, so the site, when it was submitted as a planning application, it did include some surface water flooding within the site, which was addressed as part of the application submission through layout proposals and avoiding development area within the surface water area, diverting the surface water area to provide a slightly different location for the corridor, and was considered acceptable as a consequence by the local lead flood authority. However, circumstances have changed. The Environment Agency, as they do, update their modelling, and the figure 2 that you see as part of the technical note that's just been handed around shows the site in the context of the surface water flooding map. And you'll see actually there is, with the exception of a very, very small area, the very northern extreme of the site, and equally a very small area at the extreme south west of the site, that it is now devoid of any surface water flood risk. So I think what that would mean for the purposes of this appeal inquiry is that it's reassuring, I suppose, that the matter had been addressed anyway. But the reality is, based on the Environment Agency mapping, the extent of surface water flooding has reduced significantly.
All right. And we'd better give that an inquiry document number, I think, Madam. 14. Yeah, perfect. Thank you. Good. Unless there was anything else, Mr. Packer, you wanted to add?
No, I don't think so.
No,
Thank you.
Good. Thank you very much indeed.
Thank you, Mr. Packer. Mr. Green, when you're ready.
Thank you very much, Madam. Good afternoon, Mr. Packer.
Good afternoon.
Policies, again, see if I can find common ground first of all. We can agree that the appeal proposals involve conflict with policy RE1.
So could you be more specific, please, with identifying the specific conflict?
Very well. And I thought this was common ground. Indeed, it's in the statement of common ground, but you want to be taken to the policy, absolutely fine. CD 5.1, please, RE1, page 113 of the document.
Bear with me just a moment, just getting it in front of me. Yes.
It says within areas shown as countryside beyond the green belt on the adopted policies map, and we're agreed we're in that area.
Yes.
It says the intrinsic character and beauty of the countryside will be recognised and safeguarded in accordance with the NPPF. The appeal scheme will not safeguard the countryside from harm, will it?
No, I accept that, but I would qualify it on the basis that that would apply to any site within the countryside.
Well, it depends on the proposal. It depends on the state of the land being developed, doesn't it?
It does, and that is why I'm qualifying it, because I consider that the assessment of constraints that has led to the identification of the development area on the parameter plan has had a positive influence on the extent of that conflict.
I just want to keep things simple for my sake, if no one else's. We can agree that the appeal scheme does not comply with policy RE1.
It does not.
Thank you. Policy RE3, if you go forwards to page 127, you'll see RE3 set out.
Yeah, just bear with me. Appreciate it's not too far away. Yes.
And it says, to begin with, new development must respect and where appropriate enhance the distinctive character of the landscape in which it's located. And we can agree, can't we, that the landscape in question is countryside?
Yes.
We can agree that the appeal scheme does not overall enhance the character of the appeal site.
No, but again, I would just qualify that by the requirement to enhance is a very high bar in the context of development on a greenfield site.
And if we then move on to Roman 4, which is the part dealing specifically with areas of strategic visual importance, it begins by saying, pending a review of the detailed boundaries in local plan part 2, the areas of strategic visual importance will be retained. And we know, don't we, that there has been a review in part 2 and the boundaries are, as we've seen on, I think it's page 86 of the document.
Yes.
So the appeal site is still within an area of strategic visual importance.
Yes.
And it says the policy, that is, the appearance of the ASVI will be maintained and enhanced. And we can agree, can't we, that the appeal proposal will neither maintain nor enhance the ASVI?
I would disagree with that to the extent, again, that maintaining, I would suggest, yes, in the context of the assessment of the constraints that was undertaken with regard to landscape and the consequential restriction of the development area to the lower parts of the site. Again, the reference to enhance, I think, is a very high bar that all sites that involve development of a greenfield site would fail to pass.
Will the development as a whole maintain the appearance of the ASVI?
So, in the context of the specific categories within LPP1 that are referred to, i.e. coalescence and the and the maintenance of green wedges, fingers that extend into the built-up area, I would suggest it does maintain those functions.
Right, I'll try again. If you look at the policy in front of you, it's quite a short sentence and it reads, the appearance of the ASVI will be maintained and enhanced. Are you saying that the appearance of the ASVI will be maintained by the appeal scheme?
Technically, no, it won't, because it's development of a greenfield site within the ASVI. I'm just reiterating again, if I may, qualifying it on the basis of the functions of the ASVI that are set out within Local Plan Part 1 policy.
Right, well, I mean, we can all read the Local Plan Part 1 and 2 for ourselves, so I'm not going to ask you questions about that. Can we go on to FNP 10, please, in the neighbourhood plan, core document 5.5. And it's page 44.
Yes, bear with me. Yes.
It begins by saying outside of the built-up area boundary is defined, and we are outside the built-up area boundary, are we not?
Yes.
Priority will be given to protecting the countryside from inappropriate development. A proposal for development will only be permitted where it would, and I think you say, and it's common ground, you have to comply with all the criteria.
Yes.
The first criterion looks to specific types of development, and we can agree that the appeal scheme is not for any of those.
Yes.
The last criterion is that the development enhances the landscape value of the countryside. Again, I hope we can agree the appeal scheme does not do that.
Yes, again, I'd make the same point that enhancement in the context of development of a greenfield site is very challenging, if not virtually impossible.
So, and I hope, putting it shortly, we can agree that the appeal scheme does not comply with RE1, RE3 or FNP10.
We can I just give a further qualification on FNP10, which is set out in the brief, which is I have assessed each criteria in turn in terms of it, whether the appeal site is compatible. I will leave with you, Ma'am, to read through those relevant parts of my proof. In short, what I'm trying to say is that there is clearly a preference to avoid sites of more significant landscape and policy designations. It's as set out in FNP 10B, protecting the green belt. We are not in the green belt. C, conserving and enhancing the beauty of the Surrey Hills AONB and its setting, of course, now national landscapes, which you've heard from Ms. Eade, that in her opinion, which I agree with, it does not. And also criteria D, which relates to specific maps within the neighbourhood plan. Map E relating to areas that have higher landscape value, and sensitivity in map F, which relates to Old Park, which has high landscape sensitivity and historic value. The site is not within either of those either. So I would just like to add that qualification, if I may.
Thank you. Now, you have referred, and Mr. Lytton referred in cross-examination to policy SP1 of the local plan, part 1. If you can go to that, please. It's internal page 34.
Thank you. Uh, 34?
Yes.
Yes.
I think this plan was adopted at a time when local authorities, in order to show their loyalty to national policy, included policies within their own development plan that essentially repeated the presumption in favour of sustainable development in what was then NPPF 2012.
Yes, I believe that's correct. Yeah.
So that's all SP1 does. It, I mean, to put it crudely, it just regurgitates what national planning policy said at the time.
Yes.
It doesn't say anything about where development should go, does it?
I'm just scanning. No, I can't see that it does.
We have the very broadest of spatial strategies in policy SP2.
Yes.
And you've referred, I think, to the first part of that, avoiding major development on land of the highest amenity and landscape value. And then the second, focusing development at the 4 main settlements, Farnham, Godalming, Hazelmere and Cranley. And you can see at the bottom, after the policy, there's a box entitled delivery.
Yes.
And one can see how the policy is to be delivered. It's by the local plan part 2, which will have site allocations, by neighbourhood plans, and by decisions made on planning applications, and any subsequent policies and guidance that amplify the broad strategy.
Yes.
At the time this policy LPP1 was adopted, it was anticipated that there would be a local plan part 2 that would contain allocations and development management policies.
Yes.
And there would also be neighbourhood plans.
Yes.
And it is those later documents, daughter documents perhaps, that defined built-up area boundaries. That's right, isn't it?
Yes.
And had rather more detailed policies on where development was and was not acceptable.
Yes.
And the development plan has to be read as a whole. Is that fair?
It does.
And it's in the Farnham neighbourhood plan that the built-up area boundary is defined.
Yes.
And where the acceptability of development within and outside the settlement boundary is determined.
Yes.
So far as effect on character and appearance is concerned, again, not wishing to be rude, you don't add anything to Mazid's evidence, do you?
In terms of landscape?
Yes.
No, I agree with her evidence. Yes.
I just don't want to cover ground that I've...
That's fine.
No, that's good. So far as the amenity of residence is concerned, it's fair to say, isn't it, that it's your proof and Appendix 7 to it that produces the first assessment of the noise impacts of traffic on the amenity of residents along Keepsake Close.
Yes, it is. Subsequent to the determination of the application against the officer recommendation, because there was a specific reference to the effect on amenity, we decided to undertake a noise assessment to clarify, in our view, that there was no adverse effect from noise as a consequence of traffic generation. That was the rationale behind it.
Yes, and we have seen the document itself, and I have almost hot off the press an email which has the updated assessment with the revised, corrected traffic generation figures.
Yes, I believe that's in circulation now.
And I think it's right to say, isn't it, that the relevant paragraph, it's paragraph 6.6. It's essentially the same format as the earlier assessment. We have at 6.3 the revised tables.
Yes.
Someone has helpfully marked them or changed the directions to northbound and southbound, which makes a bit more sense. Sorry, madam, I'm talking about a document. I don't know if it's made its way to you. Good. And we can see that there are the higher traffic generation figures there. And at 6.6, the experts have assessed the increase in noise level against the background, and the increase has gone up to 13.2 decibels, 6.6.
Yes.
And it remains the case, not surprisingly, that increase in noise would be considered to be of major significance when assessed against DMRB.
As an increase?
Yes. Yes. Well, it's the residents who will experience this increase if permission is granted and development proceeds. And they're obviously currently enjoying a relatively tranquil environment, and that will change significantly, won't it?
Well, it will change significantly in terms of the increase in the decibel level, but the consequential decibel level that it reaches is still well below what we considered acceptable by the World Health Organization.
I think the other aspects of the likely effect of the development, the inspector can judge for herself. I mean, we have the traffic data, we have the plans. A site visit has been carried out, a further site visit will be carried out, so I'm not going to go into that any more. So far as the performance, and I'm jumping back a bit, the performance of the Farnham neighbourhood plan is concerned, looking at the document ID 11, the site delivery table.
Yes.
We have to bear in mind, and I think you referred to a need to produce or see the construction of 697 dwellings.
As a minimum, yes.
Yes,
And
that's over the plan period, isn't it?
it is.
Yep, to 2032.
Yes.
And in addition, obviously, to the allocations and delivery on them, we have the evidence of the windfall delivery as well, don't we?
We do. What I would qualify in terms of windfall is, of course, that they will be, by their very nature, very small sites that will not be providing for, very unlikely to be providing for affordable housing.
Nonetheless, it's essential, of course, that they're taken into account when assessing the overall housing need and delivery.
Yes, if they are delivered as completions, yes.
I'm going to move on now to the MPPF in paragraph 14. It's become a much loved policy. Let me know
Yes.
when you have it.
Yes.
Good. And it's relevant only where paragraph 11D applies.
Yes.
So it's relevant only where, in the cases or in the case of housing development, it's relevant only where the most important policies for determining the application are deemed to be out of date for one of the various reasons.
Yes.
Yeah. So that's the starting point. The context is always for housing schemes, paragraph 14 of the MPPF applies where there is in some form or other a housing shortfall.
Yes.
We know that there are two paragraphs or two sub-paragraphs to be met, A and B. A is not an issue. B, if I can just understand your position, do you accept that the neighbourhood plan has within it an identified housing requirement?
Yes, it does, based on the requirement that was relevant at the time.
Do you agree that the neighbourhood plan contains policies and allocations to meet the identified housing requirement in it?
That was relevant at the time, yes.
There is no other qualification in paragraph 14, is there? Those are the only two requirements to be met, aren't they?
They are, but criteria B does take you to paragraphs 69 and 70.
Absolutely right. Let's go to paragraph 69. It's concerned with strategic policy making authorities, and by all means read the whole paragraph. This is concerned essentially with plan making, isn't it?
It is essentially, but I don't think it precludes that being applied to decision making either.
We can see at 69, it's really the second half, I suppose. Within this overall requirement, strategic policies should also set out a housing requirement for designated neighbourhood areas, which reflects the overall strategy for the pattern and scale of development and any relevant allocations. Once these strategic policies have been adopted, these figures should not need retesting at the neighbourhood plan examination unless there's been a significant change in circumstances that affect the requirement. It's concerned with first, strategic policies in the development plan, and second, the formulation of the neighbourhood plan, isn't it?
Yes.
And at the time the neighbourhood plan was made, in this case, there were strategic policies that identified a requirement, and those, well, that requirement was broken down, and there was a specific requirement for the Farnham neighbourhood area.
At the time,
Yes.
that was relevant, yes, in terms of the Waverley local plan part 1.
Yes. So the policy requirements were all met.
Yes, at that time.
Yeah. Well, there's nothing that says that the neighbourhood plan having been made, its need having been identified and policies and allocations produced to meet that need, that should change if the district housing requirement changed because of a change in national policy or whatever.
I would read that differently in the sense that it does not, what the paragraph does not do, it doesn't make any reference to that being applicable to a planning application determination. You could argue that is because it's not relevant. I would suggest otherwise, that it could be interpreted both ways. And I think the specific reference to footnote 33, which I appreciate is moving on to paragraph 70, does, and the first sentence is where it is not possible to provide a requirement figure for a neighbourhood plan area. Footnote 33 does include the third criteria that's referenced there, bullet point, or in instances where strategic policies for housing are out of date. Now, I think that it's reasonable to suggest that that could apply to the determination of planning applications as well as plan making.
One can put forward all sorts of arguments, Mr. Packer, and the inspector no doubt will have to resolve this particular one. But the words in paragraph 70, where it is not possible to provide a requirement figure for a neighbourhood area, it plainly looks back to what was in paragraph 69 about strategic policy making authorities providing such a figure to neighbourhood plans when they're being formulated.
I agree that is the primary interpretation, but I also consider that that can apply to the determination of applications at any point in time afterwards.
Well, let's just see how that would play out then. Paragraph 14, going back to it, of the MPPF, as we've agreed, only takes effect where there is a housing shortfall in housing development cases.
Yes.
And you're suggesting that in those circumstances, one should effectively ignore the identified housing requirement in a neighbourhood plan and look at something else.
There's a related point that it is not, I don't think the assessment of paragraph 14 necessarily is exclusive to the determination that there is no 5-year supply. I think it's reasonable to also suggest that the paragraph could apply to situations where a development plan on which housing requirements are based is more than 5 years old.
And where do you get that from?
So it goes back to the point I made that, as we have discussed and agreed at the point in time that the neighbourhood plan was made, it did identify sufficient sites at that time to meet the requirement that was relevant to the context of the local plan part 1. Circumstances have now changed so that that requirement is out of date. The local plan is out of date by virtue of it being more than 5 years old. So therefore the requirement that the neighbourhood plan is based upon must be regarded as out of date.
If you look at paragraph 14b, it applies where the neighbourhood plan contains policies and allocations to meet its, that is the neighbourhood plan's, identified housing requirement. Neighbourhood plans, when they make allocations, are plainly intended to meet the needs identified in the neighbourhood plan. They can't seek to meet needs that haven't yet been quantified at some stage in the future, can they?
No, but I think what this does do is demonstrate the significance of plan making in delivering housing and ensuring that the housing that is delivered is done so on the basis of the need. So in this case, the need has increased significantly as a consequence of the local plan part 1 being more than 5 years old. We've had that step change in the requirement. So the neighbourhood plan, yes, it provided for the allocations that were the required housing, I should say, that was necessary to meet the requirement, but that was only at the time that was relevant, i.e. the requirement that was set out in Local Plan Part 1.
The reality, Mr. Packer, is that if your interpretation is right, paragraph 14 is never going to apply, is it?
Well, can you qualify that, please?
Well, I'm trying to imagine a set of circumstances where it would actually apply where there is a shortfall in the housing land supply. Because your argument will always be, well, because of the shortfall, the housing requirement has changed. Therefore, the neighbourhood areas requirement has changed. Therefore, the allocations and policies from the neighbourhood plan don't meet the identified need, and therefore paragraph 14 doesn't apply. It would make a nonsense of this provision.
So you could, well, there is a scenario where you do not have a 5-year supply. Sorry, you do have a 5-year supply, but your neighbourhood plan, sorry, I'm losing my train of thought here. So you could have a scenario by which your requirement figure is, sorry, could you repeat this again? I'm just trying to get it sorted in my head.
Right.
Sorry.
You're not the only one, Ms. Packer. I'm trying to understand how your analysis would ever work. There isn't a sufficient housing land supply. The requirement has therefore changed from the time that the neighbourhood plan was made. So you say that the policies and allocations in the neighbourhood plan don't meet its current requirement.
Yes.
Well, that's always going to be the case whenever there's a housing land supply shortfall. No neighbourhood plan is ever going to be saved by this paragraph in those circumstances.
So, well, if you have a scenario where you do have a 5-year supply. No, okay, I accept the point. Yeah.
Mr. Packer, thank you very much indeed.
Thank you, Mr. Green. Thank you, Mr. Packer. I think possibly a break would be good. It's 20 to 4. I think everyone probably needs one. So, well, it's just coming up to 15:43 actually on mine. So we'll adjourn now and we'll reconvene at 4 p.m. Okay, thank you, Mr. Packer. I'm afraid you'll obviously have to sit by yourself for a while. Right, it's 4 o'clock and we will reconvene. There's one, before we move on, there's something that's troubling me. I received, so earlier on via email, I received the Glivia 3 and we had a discussion about whether or not that should be an inquiry document or because it was amendment to the core documents and we said it should be an inquiry document. However, I think in my notes, I've marked it twice. So I've ended up with inquiry document 12 and inquiry document 13 for that. I'm not sure how I've managed that. Could I have a paper copy as well? Could somebody print me one? Just because otherwise I get in a pickle. And then that would then mean,
Both, because there is the clarification, landscape clarification, and then there is the separate technical note about how you assess value.
right, and I think that's where I've got confused.
Right, they are two separate documents.
Yes, right, then that, so,
Both.
yes, please. I would like that. And then that also means that my numbering wasn't in fact out. Because then the Glivia will be ID 12, the technical note will be ID 13, which is what I had here. I looked back at my emails and I couldn't find a second document and I was thinking, I've only had one come in. That's the problem with things being submitted electronically. So then the technical note for the surface water flood risk update will be ID 14. And have you had a chance, Mr. Lisson, to look at the representations that were made
I
by someone from your team? No, I appreciate you haven't. You've been,
are we happy with a
Yeah.
yes.
super. So can I have those handed up to me from the council? I won't sit here and have you all watch me mark them all up now, but I will add those to the inquiry documents. And then I will make a note and that can be added to my list that I circulate. But they will essentially be 15 onwards. Thank you. If I hadn't have done that then, I would have forgotten and we'd have all gone home tonight and then I'd have been cross. So to reconvene the technically re-examination of Mr. Packer, there are some questions I imagine from interested parties. Are there questions from interested parties? Yes. So, Mr. Lasson, I'll leave it to you as to whether you would like to re-examine and then hear questions or whether you'd like the questions first. And then you can, yes. So, interested parties, Councillor Coburn?
Yes, thank you, Madam. I was a little bit confused with something Mr. Packer said. I just really wanted to clarify something. Are you aware, Mr. Packer, that the Borough and the Farnham Neighbourhood Plan calculates windfalls on a different basis?
Or between them, between the Borough Council and the neighbourhood plan? Is that what you mean?
No, I mean, at the time we were doing the neighbourhood plan, we agreed a policy with the borough, but the borough allocates sites differently from how the neighbourhood plan does. It's very simple. We don't allocate sites under 0.2 hectares in the neighbourhood plan, whereas the borough sort of doesn't allocate sites under 5, you know. So we have a different, we agreed it at the examination in public, but it does mean that our windfall sites come in at 24, 25. And in fact, the last three I've just remembered off the top of my head, Courtyard 23, Hookstyle 24, and East Street 23. So when we talk about windfalls, we are talking about quite a large quantity in the town, larger than if we calculated it in the way. And we did that deliberately.
Okay, that's fine. I was going by the only evidence that I've seen, which is Appendix 2, I believe, of Mr. Sampson's proof, which was a list of permissions within Farnham. And that includes the vast majority that are very small. I accept that there are some within there that are of the 20 plus kind of numbers, but the vast majority are very, very small. And I would also add, as far as I'm aware, that they are permissions rather than any completions. I haven't seen any evidence of completions other than the broad reference to windfall, but I don't know the detail of those sites.
Yeah, no, I think that's fine. Thank you, madam. I just really wanted to clarify that for the whole building, because it isn't true to say that we only have small windfall sites in the town, whereas the borough, that is true, but it's different for the town. And it was an agreed difference and accepted at the 2 examinations in public that we've had on the neighbourhood plan.
Thank you, councillor Coburn. Councillor Powell?
Thank you very much, ma'am. You talked a lot about the significance of plan making. Can you just explain to me what you believe a sustainable location to mean?
So I consider it is a relevant material consideration in its own right, locational sustainability. So it would simply be the proximity to facilities and services that would be used by the everyday person, and that proximity being such that it is possible to use alternative modes of transport to the car to access those facilities.
So if there is a shortfall in facilities such as school places, for example, that would mean that children in the locality were unable to walk to a school because the capacity did not exist, would that still be a sustainable location?
So that is the purpose of the SIL payments, is to provide contributions towards the enhancement or provision of those facilities. I cannot comment on the individual specific facilities and whether they have sufficient capacity or not, but the point being that the responsibility in terms of the applicant, the developer, is to provide those SIL contributions. It then rests with the local authority to deliver the necessary infrastructure.
And so you would accept that when a neighbourhood plan is put together, one of the issues that's considered is the infrastructure that's available and the land that is required to support such infrastructure?
Yes, and the local planner. I mean, it's important that they are delivered collectively. But that, again, that is the purpose of the SIL payments, is to ensure that whatever provisions are put forward within the neighbourhood plan or the local plan in terms of infrastructure are implemented. And that is done so in part, at least, through SIL payments that are made by applicants towards those facilities.
And you would accept that if a number of houses being proposed in a particular area is increasing for whatever reason, that the infrastructure requirements would also therefore increase?
There will be. However, I have seen no evidence, and no evidence was presented within the committee report or the determination of the application to suggest that there was a specific capacity issue with any of the infrastructure.
Have you seen Appendix 3 of the representation I made to this appeal?
I have not. Is that what has just been circulated?
No, sir, it was part of my representation that was, well, it's actually part of the response I made to the planning application, and then I did more work with Surrey County Council, LEA, in the meantime, and presented something in Appendix 3 of my representation to this appeal, written representation.
I have not seen that, so I appreciate it was available. What I would say is that had that been a significant issue for the local education authority, they would have written to Waverley Borough Council expressing their concerns, and I have seen no consultation response from them.
So there was a consultation response from the LEA in my, sorry, that's not a question. So I will rephrase that as a question. My apologies.
No, it's fine, councillor Powell. Also just to flag up, the witness can't give answers to a document that he's not read.
No,
so if he
I
hasn't
completely
read the
understand that, ma'am. So just it for context as part of the question I'm going to ask you. So that one of the things that, are you aware that in the Waverley call for sites, there was no call for sites for schools in Farnham?
I wasn't, no.
And would you anticipate that if the number of housing in a particular town was going to increase, you would look at the capacity of schools?
Yes, but that should be part and parcel of a local plan or a neighboured plan, would be to determine whether or not it was necessary to enhance, add to facilities and services to meet that additional capacity.
Are you aware that there is a Waverley infrastructure delivery plan?
Yes,
And are you aware that that identified in its most recent version 4 form entries short of secondary school places in Farnham?
no, but I would refer to the committee report because this matter was considered, and I'm looking at it now. So there was a, this is page, no page numbers, that doesn't help. It is under the heading of infrastructure within the committee report. I've got an electronic copy, so I cannot see any page numbers. But if I could just read that, maybe that would assist. So officers recognise there are pressures on infrastructure, and this development, as with any development that provides residential accommodation, would add to these pressures. However, the route for raising funds to improve the physical infrastructure is via SIL. The SIL charging schedule has been set up specifically to collect money that is used to fund the physical infrastructure which is needed. The infrastructure delivery plan 2016 prepared to support the local plan demonstrate that relevant consultees considered that the housing growth set out within the local plan covering the period to 2032 could be sufficiently supported by existing and planned infrastructure investment. I think the officers have considered this and dealt with it within the report.
And you would accept that money is one side of it, but also land needs to be allocated if you need to build a new school. You would accept that in any circumstances, irrespective of whether it was Farnham or somewhere else. If you need to build a new school, you need a site for that school.
Yes, but that is the responsibility of the council to ensure that the local plan provides for the infrastructure that is required to support residential development.
And you would accept that the local plan is based on a number of houses to be delivered, and if that number increases, then obviously the infrastructure associated with it will also change.
Yes, but again, the route to ensuring that infrastructure is provided appropriately is through the local plan.
And you would accept that development outside the local plan, the infrastructure for that is therefore not necessarily considered.
No, I don't accept that in a situation where the council has under-delivered against 5-year supply, because the implication of that is that they are not meeting their housing requirement.
And you would accept that there is a spatial element across Waverley in terms of where housing delivery was planned and where it is not being provided versus where it is being provided would impact on infrastructure requirements, given the size of Waverley.
I don't have evidence in front of me to qualify the extent of residential development in Farnham relative to the rest of the borough. I don't feel I can comment on that.
Thank you, sir. That's it. Thank you, ma'am.
Thank you, Councillor Powell. Were there any other questions? Mr Tilbury?
Thank you, ma'am. I was going to give paragraph 14 another trip round the block at some length, but in view of the concession to Mr Green before the break, I don't think there's any need for me to do that. What I would, just one question then. We heard from Mr Bell yesterday that he considered that the impact on the residential amenity character of Abbeyview was sort of akin to phase one of a multi-phase development, and the implication, I'm putting words in his mouth, but I don't think it's totally unfair, that the residents of Abbey View could not unreasonably, it was unreasonable for them not to expect construction traffic to be going up and down their finished residential roads because they were living, as I say, on phase one of a multi-phase development site. In your experience and your judgment, is that a fair characterisation of where residents in Abbey View should feel that they live?
I think it is reasonable. It is quite relatively common, I should say, for greenfield sites to be put forward on the edge of settlement areas, and often that will require access through an existing residential development. I don't think it is that unusual. So in the context of an authority with a lack of 5-year supply, for example, it is not unreasonable for applications to come forward that do provide for access through existing residential areas.
If I may just follow that up, just to say, the way he put it was that the impact upon their daily lives, as it were, that they were overstating perhaps the extent of the impact that they would suffer, and that they ought to have known that this was going to happen, as you would do if you were living on phase one of a multi-phase residential development. There, it would be reasonable to say to the residents, well, you knew where you were buying your house. You knew what was to come next. Don't be surprised if your roads aren't finished and there are HGVs going past it. Is that really a fair characterisation of the Abbey View residents' position?
So, as I said, I think the context is important. It's easier for me, and probably you as well, to understand with planning knowledge that this is always a possibility. I think if you are a resident and you're moving in, I suspect that's probably not on your radar. Why would it be? But I think in the context of planning, we can all understand that these situations will arise. I think in terms of the significance of the impact, I think we've run through that already. I'm not suggesting that there isn't an impact. What I am suggesting is that is minimal, and that is very specific to number 18, Keepsake Close, in terms of amenity considerations. There is no adverse effect on the basis of the normal appreciation of adverse impacts on the amenity of the remaining residents, in my view.
Perhaps just to be a little bit cheeky, if you won't mind, and the inspector won't mind, to say, have you read the written representation that Farnham Town Council made to the appeal with the examples we gave of appeals where similar arguments to the ones that you had made in respect of Para 14 had been placed before inspectors previously?
I suspect I did some time ago, but I do not have that in front of me and I cannot remember, I'm afraid.
Thank you, Mr. Tilbury. Are there any other questions from interested parties? Okay, all right. I don't have any questions. Well, it might, no, I don't think I don't actually. It might be that if I do have any, I'll jump in, but if it comes, but at the moment I don't have any. So yeah, so sorry. So thank you, interested parties, Mr. Packer, and if you'd like to re-examine.
Yeah, so I've only got paragraph 14.
Okay, yep, thank you.
Because the premise of the question that was put to you in terms of paragraph 14. The premise of the question that was put to you in the context of paragraph 14 is that paragraph 14 only applies where there is a shortfall in housing land supply. So let's have a look at that, and you can see that because what paragraph 14 says is that in situations where the presumption at paragraph 11D applies to applications, etc. So let's just go back to paragraph 11D and see whether it only arises when there is a housing land supply shortfall. So 11D, where there are no relevant development plan policies, is that is that a housing land supply shortfall?
No, that could also include where relevant policies for the provision of housing are out of date by virtue of the plan being more than 5 years old.
Well, that's a situation where there simply the plan doesn't exist. Now,
Yes.
I mean, I know
Okay,
that we
yes,
don't in this
yes.
country have complete coverage, but I don't think, York might be. York
Yes.
might be the one authority in the
Yes.
country that doesn't have a development plan. I'm sorry. But, so that's the first situation, or the policies which are most important for determining the application are out of date. And that's where the footnote comes
Yes,
in,
yes.
yes? So then we got to look at the footnote to see in that situation where the presumption applies. So if we look at that, so this application, this includes for applications involving the provision of housing, situations where the local planning authority cannot demonstrate a 5-year supply of deliverable housing sites. That is the premise on which it was put to you that
Yes.
paragraph 14 was engaged with the buffer, etc. Or where the housing delivery test indicates that delivery has fallen below 75% over the previous 3 years. So
Yes.
is there a situation where actually the council has, an authority has a 5-year housing land supply, but has failed the housing delivery test?
Yes.
And in that situation, does the presumption apply under paragraph 11D?
Yes.
And does that then engage paragraph 14?
No.
If A and B are
sorry, yes.
engaged,
Yes.
does paragraph
Sorry.
14 apply?
Yes.
Right.
Sorry. Yes.
Does that then mean that paragraph 14 can never apply, which is the question that was put to you, but it was put to you on the premise that it only applies when there's a housing land supply shortfall. Is that correct?
No, there are other reasons. Yes.
Yeah, thank you very much. That's it. Thank you, madam.
Thank you very much. Mr. Packer, thank you. I don't have any further questions.
Thank you.
They've been covered. So thank you for that. And you may, well, you can stay there if you like, or you can go back to your seat. I don't mind. It's entirely up to you. We don't have any further evidence to hear. So, that's what we're coming to.
Yes, well, I don't want to jump ahead, but if there isn't any other housekeeping matters, I just want to raise this one.
Yes.
And that is, I've been provided with hard copies of the documents from Councillor Powell. I don't know whether you've been provided with those yet. And it's an email plus a bunch of attachments, all relating to flooding. It's not what I asked for. I asked for the documents in the context of the Statement of Common Ground and the highway Statement of Common Ground, and the discussion that apparently that had taken place with members of Surrey County Council Highways team about the Statement of Common Ground and the like. And I was told that there was exchanges of emails or correspondence. Those haven't been provided. Instead, what I've got is an email dated the 12th of February, so today, which is retrospectively asking for confirmation about certain things. So it's not correspondence that was passing at the time that Councillor Powell was even talking about flooding, but is asking for retrospective confirmation that orifices that are of a certain dimension mean that they can't object. And the answer that actually comes back is, no, well, that's not correct. She doesn't, the relevant council officer doesn't confirm what is put to her. But I mean, this is just not what I asked for at all. So I'm not entirely sure what it is that we're supposed to do with this.
Well, Madam, I'd say my recollection was that the request related to flooding communications, not highways. But if there's a clash of recollections, so be it. I'm sure that can be sorted out. What is it exactly does the appellant want?
Well, I'd like to receive what I was told was already in existence, not an email that's been generated today.
And I understand that. What I'd like to know is it to do with highways or flooding or something else? Because
Well, I mean, I checked my recollection with my people, and it was in the context of the Statement of Common Ground and the exchange that apparently had taken place with case officer and Mr. Lahan about whether a Statement of Common Ground had been sent to them and the like. But if I'm wrong on that, certainly we haven't been provided with any documentation relating to that. If I'm wrong on that, and it is in relation to flooding, then I'm not entirely sure. This doesn't do it either, because this is an email with some early attachments of some earlier documents, which seeks to get retrospective confirmation of apparently a conversation. It's got nothing to do with an exchange of documents at the time about the flooding.
My recollection was that it was to do, the documents that were requested were the documents referred to in terms of the Statement of Common Ground and whether or not that had been pursued. No, obviously the Statement of Common Ground only ever remained in draft form anyway. There was no agreed Statement of Common Ground. I think obviously the point that was made was that Councillor Powell had tried to pursue it, and Mr. Lisson, you were suggesting if that had been the case, could those emails be provided?
Exactly.
That was my understanding of what was expected to be provided.
Yeah, and no, we haven't got any of those emails because I assume they don't exist, because if they did, they would have been
Well,
provided.
not
by now.
necessarily. That might be
Okay.
that Councillor Powell has.
No, fair. But that your recollection of what I asked for then is entirely mine as well. So they haven't been provided. Question whether they exist. What has been provided is, I say, an email dated the 12th of February, so today, in which a request is made to an officer of the council asking that Councillor Powell's understanding there is no minimum orifice size included in the SUD's guidance, and therefore you cannot object to an application based on orifice size for confirmation of that. And that confirmation is not actually given. She does not confirm that there is a minimum size in respect of which they can't make an objection. So I say I'll be provided with this documentation, but it's not actually what I was asking for, and it doesn't do what Councillor Powell clearly hoped it was going to do. But I don't know what you want to do with this, because I mean, then there are minutes of a meeting attached to this and a member's question in relation to flooding and a response to that. I mean,
well, Madam, if it wasn't requested and these have been produced under a misapprehension, then they're not relevant. And
Yeah, my concern is that we've not, if they've been submitted now and we're not going to have the opportunity to test them, essentially. Flooding isn't an issue that's in dispute between the parties, and that wasn't a reason for refusal. And I'm concerned that there isn't the opportunity for the appellant to respond to them.
no, they were plainly provided as a response to what was understood to be the appellant's request.
I think so.
They're not what the appellant wants.
Flooding was discussed. Councillor Powell did bring up flooding, and I have a note of that as well.
yes.
But that I don't have a note saying that I was expecting anything in as a result.
Obviously, there's been a misunderstanding.
Yeah, which is
can
perfectly.
Can we just
reasonable.
ignore this then?
I'm not going to accept it, because I think
No,
that would be.
that's fine. That leaves, of course, outstanding the appellant's request. Now, I can't speak for Councillor Powell. Councillor Powell can speak very well for herself. So I'm going to leave it to her. If there are documents that the appellant wants, perhaps she can produce them tomorrow, or sort of, and the appellant only, and they can be pursued at that stage if necessary.
And
Yeah.
my understanding was that there were a number of emails regarding
Yes.
the, an email chain between the Surrey County Council officer who, the appellant sent a draft to. I think Councillor Powell, you said that they informed the appellant that they were no longer the case officers dealing with it and that they should deal with so-and-so, and that you tried to then pursue that. And I think you said that you then contacted Waverley as well as Surrey to say, could they pursue this? And that, I think that was the correspondence that Mr. Lisson was asking for.
Exactly.
I don't want to put words in anyone's mouths. That's the note that I've made here. But if those, I mean, is it critical to
No,
your...
do you want, it's not critical, but I mean, it was, I think the implication that was being made was that somehow the appellants were at fault
Yes.
because we hadn't sent it to the right person and et cetera, and whether or not it was also being suggested that's part of some sort of deliberate strategy. But, it's wrong. I mean, Mr. Bell made it clear it was perfectly, it was wrong. But it was said that there are documents, emails that support that. That's what I asked for. I'm not asking for an email generated today which asks, didn't we have a conversation about this? Can you confirm? I want the contemporaneous emails that we were told existed.
Yeah,
Because
I
if they
think that's a
don't exist, then
misunderstanding in
someone's
terms
not
of
been
the
telling the
flooding
truth.
emails. But Councillor Powell, if those emails are there in terms of the correspondence between yourself and the case officers at Surrey and then at Waverley, if you are able to submit those to the council.
So I have Teams, I use Teams to correspond with the Surrey officers, so it's not an email, it's a Teams message, and I can screenshot those with their permission and send them to you. There was I have to say I took away Mr. Green and I obviously went away with the same wrong impression that it was the highway stuff, and not the flooding stuff. Sorry, it's been a very long month. So if the copy of the Teams message will help, I'm happy to do that. Or I can get the officer involved to just email directly to Mr. Linton, whatever would be more helpful. I mean, to be honest with you, I don't think we're ever going to agree because Mr. Linton has a view and the officers have a view and it's just different. And I can document, I mean, a lot of it has been verbal correspondence, but some of it is in Teams. I can look back, see what's in Teams and what's in emails.
I think the Teams messages not get deleted after a certain period anyway. I think they only
Oh
stick
no,
around for about
mine
12
stay forever.
I want to check the GDPR on that. I think that if the correspondence that you referred to that you have got, whether that's emails or Teams, should probably be provided for the sake of completeness, if you
Okay.
can. Don't panic about doing it today, but certainly by sort of close of play Friday would be helpful so that Mr. Litton can see it. And obviously we won't reconvene in terms of closing till Tuesday anyway.
Yeah.
So we're all happy with that. Okay, thank you. Was there anything else, Mr. Litton?
No, thank you.
No, it's just that. Right, so in terms of my housekeeping, I still don't have a paper section 106 and I still don't have any conditions.
We've been providing lots of materials, so
So could someone talk me through what's being handed up to me? Because I'm expecting things. Otherwise, tomorrow morning, I'm concerned that at the moment, I've been reading things that are not the latest versions. And we're now at the end of day 2 and I still haven't seen them. There we are, thank you. Splendid. And is this the version that includes the references that are to be struck out, or is this the version that they've been struck out on?
it still includes references. to
Okay.
Farnham Park.
Right. That's fine.
Ignore those.
Okey-doke. There was also mention of a note on the section 106 being circulated.
Yes, Smith, he's going to be here tomorrow anyway. Well, right, yes.
Super. Could that be submitted? That would be helpful to assist me in preparing. And I'm so sorry, you've been standing there really patiently. Wonderful. Thank you very much. Yes, that we asked for.
and I was handed, I'm not sure whether it's for me to distribute, hard copies of the draft conditions.
Yes, please. It's like a really dull Christmas, isn't it? Thank you. Is that everything that people want to hand in?
That note from Mr. Smith, so.
And the note from Mr.
it
Smith.
Has been emailed to the case officer, Finn's case officer. I think we're having a copy printed now. So take that away.
Thank you. Yeah, that would be splendid. So in terms of sorting these out then, the, so where's my list? So for everyone's notes, again, I will send round my understanding of the inquiry documents, but we may as well go through them as we do. So notes and clarifications. So the Glivio will be ID 12. And then assessing landscape value outside national designations, technical guidance note 0221 is ID 13, which were the two documents that we were waiting for, because then the technical note on surface water flood risk update is ID 14. ID 15 onwards, which I will go through this evening and mark up, are the transcripts of the representations that were made by interested parties. And then following that, there will also be the site visit that is asked for. Now, that was what was handed in by Mr. Free with the details of properties for me to visit tomorrow. Okay. So I'm afraid I'm not going to go through those now and give them all numbers. You'll just have to trust me that I'll do it when I get back and circulate them, which I think will be easier and slightly more efficient time. So I have the draft planning conditions and I have the section 106. And then, so tomorrow we will deal with those two matters and then we will conduct the site visit after lunch. And then that will essentially be all evidence heard, and we will adjourn after site visit, and we will then, well, I'll keep the inquiry open for the site visit, but I don't intend to hear any evidence. We will adjourn and then reconvene on Tuesday for closings virtually. Is the council preparing a link and sending and circulating for? Is that all in hand? 10 a.m. Does that work? I'm conscious that does that give you time to get back and prepare, because you'll want to have seen Mr. Green's closings as well.
That is the time I have.
I'm happy to start at 10:30 if that would assist.
That is fine. 30, just, right.
Fair enough. Okay, so yes, if you could circulate the joining link, that would be helpful. And also update the appeal website on the council's website just to confirm that closings will be heard virtually. That we won't be reconvening here next Tuesday. I don't have anything else. I'm coming back tomorrow. Mr. Liston, obviously you're not. Mr. Green, are we? You'll be here tomorrow, right? If nobody has anything further, nope, I'm answering for you. Then thank you. Thank you to the witnesses for the evidence and for the interested parties for your questions and your participation. And we will adjourn now at 20 to 5, so everyone gets away a little bit earlier, and reconvene tomorrow at 9:30. Okay, thank you.
I just say thank you to the council and the